Hi, my name is Michael Burstein. I'm an estate planning attorney and probate attorney in West Los Angeles and with a second office in Manhattan Beach, California. I've done a series of videos on various estate planning concepts that I frequently am asked questions about. Today I wanted to talk in a more general terms about the Tax Act and its effect on estate planning. The Tax Act that was passed and signed into law by President Obama in December of 2010. That Tax Act, while it deals with all kinds of taxes in all areas of our lives, had some specific estate planning provisions that those of us in the estate planning community had been waiting to hear about or learn about for the last couple years. In fact, most of us thought that in the summer of 2009, a bill would be passed dealing with what we call the applicable exclusion amount. As 2010 obviously was right on the corner, and some of you may know that in 2010 was the first year since 1916, that there wasn't any estate tax. We, estate planning attorneys, academics, those that think about the subject, didn't think we would ever have that untaxed year of 2010, but we certainly did. In December of last year, just 2 months ago, a bill was signed by the President that dealt with a lot of those issues that we thought would have been dealt with in 2009. The biggest things for us to talk about are the following. One, the increase in the applicable exclusion amount. Currently, under law for this year, 2011, as well as next year, an individual can have $5 million and not be subject to any estate tax. Therefore, a couple can have $10 million. Just 10 or 11 years ago, those numbers were $600,000 or $1,200,000 for a couple. So there's been essentially in the last 10 years an over 8 times increase in the amount a couple can have or an individual can have before there's any estate tax. Similarly, one can now give away $5 million before, or a couple $10 million before there's any estate tax. So many wealthy people like to give money away to generally their children so that they get assets out of their estate so those assets are not subject to estate tax upon their death. Now, I must caution, the law is only for 2011 and 2012. Sometime next summer, the summer of 2012, we anticipate, or towards the end of that year, that Congress and the President will have to get back to work and determine where we go going forward. Finally, the third big change that affects many people is the fact that there is what we call portability. Meaning that if someone passes in a couple situation and he or she has an estate under $5 million, the difference between $5 million and the value of his or her estate is portable and can go to his or her spouse. So for example, if I were to die with an estate of $2 million, then $3 million can go to my spouse as far as estate taxes are concerned, so she could have an estate of $8 million before there would be any estate taxes. That is what is known as portability. We don't know if it will continue past the year 2012, but it is currently the law. In the event you have any questions on anything I have spoken about today, please do not hesitate to give me a call at 310-391-1311. I look forward to speaking to you. Thank you.